Hello everyone, this is Aparna Bhat and welcome to our YouTube channel Abhijna Legal Maps. So this is a YouTube channel specially dedicated for those students who can follow law lectures in English, because there are many students all over India who would like to want to listen to English lectures because they may not be following the regional languages or Hindi, they may not be understanding. So this is the YouTube channel exclusively dedicated for those students who would like to listen to the lectures in English, law lectures in English. Okay. So we also have a Kannada YouTube channel Abhijna Law Series, which is specially dedicated for Judiciary Exam preparation and All India Bar Exam preparation. And this channel, this is catering to the needs of like all law students, be it Judiciary or All India Bar Examination or any kind of legal related issue. So if you are interested, then definitely do subscribe to our YouTube channel. And also this particular topic is regarding the All India Bar Examination question paper, which is being solved part by part. So we are solving the most recent question paper, that is 2023, that is All India Bar Examination 18 question paper. We are solving 25 questions in one go, in one stretch. This would be part 1. I would be solving the remaining questions part 2, part 3, part 4 in the next upcoming videos. So this solving of questions would be entirely in English, and I also would like to ask you to I'd like to ask you to have a bare act with you before I solve the questions. Okay. So we will begin with the today's class. So the first question, which of the following is incorrect with respect to the, okay, sorry, wait. Yes, which of the following is incorrect with respect to the diary of proceedings in investigation as per the Code of Criminal Procedure 1973. So this is a question regarding Criminal Procedure Code CRPC 1973, and the question is regarding diary of proceedings. So diary of proceedings, we can find it in section 72. So the police, when they maintain the diary during the investigation, so that has to be, all the case details has to be included in the diary. So as per section 172 of CRPC, the witness statements have to be recorded in the diary. That is true, and it should be properly in volumes and properly paginated. Page numbers have to be included, it should be duly paginated, and it can be used by the police officers to refresh their memory. See here, the important condition is that the court, the diary, whatever the diary they are using, that cannot be used as an evidence because it contains very minute details, very confidential information also. It could be regarding the whistleblowers also. So that is why it cannot be used as evidence, but police can use it during their evidence to refresh their memory, because they might have forgotten some of the facts regarding investigation. They can just use it to refresh their memory. So this is the true statement, but this is wrong, because the diary may be used as evidence. No, it cannot be used as evidence. Section 172 clearly says that. Okay. So that is why C is the answer. C is the incorrect statement with respect to the diary of proceedings. So section 172 CRPC is the correct answer, and with reference to the BNSS, the corresponding section is section 192 BNSS. Okay. So this is the first question. The second question is, which of the following cases is the manner of conducting an offence not required to be mentioned in the charge as per the CRPC 1973? See here, this is a question regarding charges. Okay, we have a separate chapter known as charges. There we find section 213, where it says that in some of the charges you must also mention the manner, the way in which a person has committed an offence. So for section 213, they have given various illustrations. So the question is regarding the illustration. So among the illustrations, we can see that the first illustration itself says that regarding theft, no need to give the manner in which it was committed. But for the rest of the answers, we see that maybe it could be cheating or disobeying a direction of a public servant, or regarding giving false evidence. In all these cases, the manner in which the offence was committed has to be mentioned. Okay. So that is why the proper answer is A is the correct answer, and the corresponding section is section 236 BNSS. Section 236 BNSS is the correct answer. And the third question, which of the following offences may be tried summarily as per the CRPC? Okay. So, summary trial comes under section 260. Section 260 CRPC speaks regarding summary changes, summary trials. So, BNSS has introduced many changes in this particular section. So, this question was actually withdrawn. They haven't because the question or the answer they were differing. So, they have withdrawn this question in All India Bar Examination 18. Okay, but let us understand the question, let us understand the provision. Section 260 says that it was not mandatory, it had given certain list of offences which say that these offences may be tried summarily, and one of them was those offences which are not punishable with death, which are not punishable with life imprisonment, which do not exceed 2 years, they may be punished summarily. And also section 454 also could be tried summarily, under section 504 also they could be tried summarily. Okay, only death, life imprisonment cannot be tried summarily. But now the change is that section 283 BNSS, the corresponding section is section 283 BNSS, we can find the question here. So, it has made it shall, and Metropolitan Magistrate, Assistant Sessions Judge, BNSS has omitted those provisions. So, the Metropolitan Magistrate section has been omitted here, and the 2 years has been increased to 3 years. So, those offences which are punishable with not exceeding 3 years of punishment, even they can be tried summarily, and the value of the theft, the value of the property which has been subjected to theft, earlier it was 2000 rupees, now it has been increased to 20,000 rupees. So, these are some of the changes here. So, here we cannot directly say because all these can be tried summarily, this cannot be tried summarily. So, the question does not matches with the answer, that is why they have withdrawn the question. The next question, the fourth one, which of the following section of the CRPC provides for a reference to High Court? So, CRPC provides appeal provisions, reference and revision. So, this is a direct question. A court, when there is the magistrate or the sessions court, when they are having the question as to the validity of a particular act or a substantive question of law is involved, they can refer the matter to the High Court. So, section 395 CRPC speaks regarding this. The corresponding BNSS section is section 436 BNSS. Okay. Next, the fifth question, the person accused of the following offence may not be granted bail under section 438 of CRPC. So, section 438 speaks regarding the anticipatory bail. Anticipatory bail. The corresponding section is section 482 BNSS. So, not many changes have been included except the section numbers. So, it says that for some of the rape offences, sexual offences, anticipatory bail cannot be granted. So, it has given the list of certain offences. So, as per section 438, offence under section 376AB, 376DA or 376DB, all these things cannot be subjected to anticipatory bail. For them, bail cannot be granted. That is why D is the answer, 1, 2 and 3. These are the answers. Next question, sixth question. Which of the following acts, if done by a magistrate, even in good faith without being empowered, shall vitiate the proceedings as per the CRPC 1973? So, they have given a list of orders which are done by the magistrate. So, we have two sections, section 468 and section 461. Under section 460, they have given list of orders where even if the magistrate does not have the jurisdiction, but if he orders them in good faith, it shall not vitiate the proceeding. Under section 461, they have given list of certain orders where if the magistrate is not having jurisdiction, then whatever order he makes, that proceeding will be void, or we can say that such order vitiates the proceedings. So, these are some of the examples which have been given here. So, section 306 does not vitiate proceeding, or order made under 410 does not vitiate proceedings, but 83 it vitiates proceedings, and this one does not vitiate proceeding. But somehow, as the question was somehow wrong, this question has been withdrawn. Okay. But the answer is, which vitiates proceeding, is C. C is the correct answer. Next one, which of the following is material for deciding the jurisdiction of the civil court in the light of Code of Civil Procedure 1908? So, this is a question regarding Code of Civil Procedure. So, we have to consider a plaint in order to understand the jurisdiction. So, it is only sufficient if we check the plaint. It is not required. Written statement and all are not required. Only if plaint is checked, and there if the jurisdiction has been given, it is used to decide the jurisdiction. That is why A is the answer. Averments made in the plaint, only that is sufficient to decide the jurisdiction of a civil court. Okay. And the next question, 8th question. Which of the following cannot be considered as a suit of civil nature for section 9 of Code of Civil Procedure 1908? So, actually suits relating to pure religion, pure religious questions cannot be considered as a suit of civil nature, whereas all these suit for recovery of voluntary payments or offerings, suit for rights of franchise, suit for specific reliefs, all this can be considered as suits of civil nature under section 9 of CPC. But even this, if it relates to legal rights, that can be considered as suits of civil nature. But if it is involving purely questions of religion, religious rights, then this cannot be considered as suit of civil nature. So, D is the answer. Which of the following provisions of the Code of Civil Procedure makes the doctrine of res judicata applicable in representative suits? So, section 11 speaks regarding doctrine of res judicata, and res judicata has 8 explanations. Among the 8 explanation 6, section 11 speaks regarding representative suits. Okay. So, B is the answer. And the next question, 10th question. In which of the following situations a court will not issue summons for personal appearance to the defendant? So, the question regarding summons to a party, that comes under order 5, and summons to witnesses comes under order 16. So, we are referring to order 5, especially rule 4, which says that the defendant can be called to he can be served summons for his personal appearance if he is residing in the original jurisdiction. So, here it can be issued. If he is residing within 50 miles, even then for his personal appearance summons can be issued, and if he is residing within 200 miles, if there is a public conveyance, even then he can be issued summons to appear personally. Or section 132, this speaks regarding a woman, a Pardhanation woman who cannot be asked to appear in person. Okay. But if section 132 is not applicable, even a other woman can be asked to appear in person if she is a defendant. So, even in this case she may be asked to appear in person. But here we can see only if it is within 200 miles, if it is residing within 200 miles, only then summons can be issued. But here as it exceeds 250 miles, that is why the court cannot summon him for personal appearance to the defendant. Okay. So, answer is C. C is the correct answer, where court cannot issue summons for personal appearance to the defendant. Next one, 11th question. Which of the following situations is the plaintiff precluded from bringing a fresh suit as per the Code of Civil Procedure 1908? See here we have order 9 which speaks regarding appearance and non-appearance of the plaintiffs. Okay. So, these all are regarding dismissal, 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 dismissal. So, dismissal speaks regarding, the dismissal is regarding if a plaintiff is not paying process to the summons, if both parties do not appear. So, this is dismissal regard in rule 2, rule 3 of order 9. This is a dismissal under rule 8 and this is a dismissal under rule 9. So, whether fresh suit can be filed if such suits are dismissed, that is the question. So, rule 4 says that fresh suit can be filed if they are dismissed under rule 4, rule 2 and 3. Rule 5 itself says that, sorry, here this is Rule 5. Rule 5 itself says that they can file a fresh suit if it dismissed under Rule 5. But Rule 9 says that if a plaintiff does not appear, then the suit, if it is dismissed, then he cannot file a fresh suit again. So, he is precluded from filing a fresh suit. So, C is the answer here, C. 12th question. How many times at maximum may an adjournment be granted to a party during the hearing of the suit as per the Code of Civil Procedure 1908? So, 2 times, 3 times, 4 times, and D, no limit prescribed. So, we can see that Order 17 speaks regarding adjournments and maximum 3 times can be given. Next, 13th question. Which of the following amendment acts made the provision in the Code of Civil Procedure 1908 to produce a witness without a summons? See here, this is a question provision where a witness can be produced even without a summons. That is a provision under Order 16, Rule 1A. So, this was included by way of amendment of 1976. So, A is the answer here. 14th question. Which of the following is not included in the word costs as provided under Code of Civil Procedure 1908? So, Order 20A is the relevant provision. There we can find a list of costs. Okay? So, in those costs, the expenses of the witnesses incurred are included, legal fees and expenses are included, or any of the connected costs are included, but it does not include fooding and lodging expenses. So, what is the question? Which is not included in the costs. So, C is the correct answer for this question. 15th question. What period is prescribed under the Code of Civil Procedure 1908 for the defendant to enter an appearance for filing address for service of notice on him in the case of a suit where summary procedure is to be applied, right? So, in this case, see, summary procedure under CPC is given under Order 37, and Rule 3 says that when defendant has to appear, so defendant is having 10 days from the date of service of summons to file his address of notice, address for service of notice. So, answer is B, 10 days from the date of receiving of summons. B is the correct answer. Next one, 16th question. Under which of the following provisions of CPC may the appellate court remit an issue for trial to the lower court? So, actually this question is wrong. So, that has been withdrawn. This question has been withdrawn, but regarding remanding a particular case, that is dealt under Order 41, and we have various rules, Rule 23, 23A, Rule 24, 25, where the appellate court is having vast powers to either frame an issue, remand it for trial, or give the judgment itself, or resettle the issue, or frame an additional issue. So, it has vast powers under Order 41, that is the power of the appellate court. Order 41 speaks regarding appeals from original decree. Okay? So, all these are connected rules only. Next question, 17th question. A is accused of the murder of B by beating him. Which of the following will not be considered a relevant fact forming part of the same transaction as per the Indian Evidence Act 1872? So, here what is happening? This is a question regarding Indian Evidence Act, which is also known as a relevant fact forming part of the same transaction. This is nothing but res gestae. So, in section 6 of Indian Evidence Act, we find the illustrations here. So, if a person dies by murder, someone who has beaten him, then what are all relevant? So, whatever a person A or B, the murderer and the victim, whatever they say or whatever they do or whatever the bystanders who are looking at them, whatever they say, they are relevant. But what A had said the earlier day or B had said the earlier day, they may not be relevant. Okay, D is the answer. This is as per the illustration given under section 6 of Indian Evidence Act. So, we also have Bharatiya Sakshya Adhiniyam, the corresponding section, section 4 we have Bharatiya Sakshya Adhiniyam. Next question, 18th question. Which of the following provisions of the Indian Evidence Act says that the confession proved against a person to a police officer shall not be used against him? So, we have a very important section, that is section 25 of Indian Evidence Act. It says that whatever confession made to a police officer, it cannot be used against him. Okay. The relevant section under BSA, Bharatiya Sakshya Adhiniyam, is section 23 subsection 1, because all sections regarding confession under inducement, threat, those have been clubbed together. That is why this section 25 has been given a sub section number, section 23(1) of Bharatiya Sakshya Adhiniyam. Next one, 19th question. Under which of the following provisions of the Indian Evidence Act may a dying declaration be admitted as evidence? So, in bare act you do not find a dying declaration directly. Okay, it is found under section 32 subsection 1, where a person who cannot be found, who is dead, who had made a statement regarding the cause of his death, that is said to be dying declaration, which is given under section 32 subsection 1. And the relevant section under Indian Evidence, Bharatiya Sakshya Adhiniyam is section 26 subsection 1. Bharatiya Sakshya Adhiniyam. Next we will move to the 20th question. Which of the following is correct according to the Indian Evidence Act pertaining to proof of contents of the documents? So, Indian Evidence Act gives the section 61, it speaks regarding proof of the contents of the documents. It says that the document contents can be proved either by primary evidence or by secondary evidence. Okay. So, if we see the answers here, what is the correct answer? See here, and they have given. No, this is not a condition. You can either give the primary evidence or secondary evidence. So, that is why D is the correct answer. So, the corresponding section under Bharatiya Sakshya Adhiniyam is section 56 of Bharatiya Sakshya Adhiniyam. Lots of changes have been made in the list of what are all primary evidence, what are all secondary evidence. The list has been increased, the explanation, it has been expanded, the meaning has been expanded. Primary evidence now also includes the electronic evidence to a certain extent, and secondary evidence also includes certain admissions also, oral written admissions and everything. Okay. Next one, 21st. Which of the following is a correct statement as per the Indian Evidence Act? So, this is a question regarding leading questions. So, leading questions we have section 141, 142, 143. Okay. So, 143 exactly says that leading questions can be asked in cross examination. This can be asked in cross examination. Whereas other sections 142 and all, they say that leading questions cannot be asked in examination chief or re-examination and everything. So, that is why 146, the corresponding section is section 146 of Bharatiya Sakshya Adhiniyam. There they say that 146(3) I guess, 3 or 4, they say that leading questions may be asked in cross examination. 22nd question. Which of the following cases did the Supreme Court of India clarify the admissibility of electronic records as evidence? So, this is a question based on the case law Anwar PV versus PK Bashir. This is a case where the Supreme Court has given a landmark judgment regarding admissibility of electronic records. 23rd question. Which of the following is incorrect statement in the light of Indian Evidence Act? See, if you see the options here, you can see that the confession and admissions. Section 31 of Indian Evidence Act, it says that admissions cannot operate as, they cannot be conclusive proof, but they can operate as estoppel. Okay. And so, this is a wrong statement. Here they have given admissions are conclusive. So, that is not true. Admissions cannot be conclusive proof, but they may act as estoppel. And regarding other statement, confession always goes against the person making it. So, this is a true statement, and confession is a statement written or oral. So, it could be written also, oral also. It is a direct admission of guilt. That is also true, because confession is a part of admission. Confession is also an admission, but it is only pertaining to criminal matters where he admits his guilt. Admission can be in civil also, criminal also. That is why this is also a true statement. Okay. So, this is the correct. It operates as estoppel as per section 31 of Indian Evidence Act and section 25 of Bharatiya Sakshya Adhiniyam. Next one, last question for this video, 25th question. Which of the following sections of Indian Evidence Act is an exception to hearsay rule? Sorry, this is the 24th question. I am so sorry, another question we have. So, hearsay rule, what do you mean by hearsay rule? As per the proper like evidence, rules of evidence, the evidence should be direct. Okay, whatever we see, whatever hear, only that can be given as evidence. I cannot give an evidence which I hearsay, means someone says that he has seen the murder. I cannot go and say to the court that I have heard him say that he has murdered. So, this becomes hearsay. So, that is not direct evidence, that is an indirect evidence. So, hearsay evidence is not permitted, but due to some reasons, some exceptions are there. Some hearsay evidence is also allowed in Indian Evidence Act. They can be admitted, as evidence. So, one such example is dying declaration, so which is given under section 32(1). So, they serve as exception to the hearsay rule. 25th question, which of the following is not a recognized alternate dispute resolution mechanism under the Code of Civil Procedure 1908? So, it could be arbitration, conciliation, lok adalat and negotiation. See here, under section 89 of Code of Civil Procedure, they have recognized the alternate dispute resolution mechanisms. So, some of them are arbitration, conciliation, lok adalat. Okay, but negotiation is not recognized. Another is mediation. Mediation they have recognized, but negotiation is not the recognized alternate dispute resolution mechanism. That is why D is the answer. Okay. Yes. So, this was all about our today's class, and I would also like to bring to your notice that we also have a study material for judiciary examinations. We have already 7 books. One is regarding translation, but regarding new criminal laws, we have a quick chart book. You can find it in Amazon. The relevant link I will be giving in my in the YouTube description, and you can also find the books in our app as well. So, whichever is relevant, you can purchase the course. We have some test series, and we have some lectures which are in Kannada. Very soon we will be upgrading our app to our English lectures as well. In English also we would be teaching. So, that is why if you are interested, definitely please download the app and also subscribe to this YouTube channel, so that you have a proper update regarding whatever we upload on our English YouTube channel regarding law lectures. Okay. So, this was all about our today's class. So, do follow, subscribe, and do not forget to share it among your friends. We also have a group which you can join, the description which I have given in comment box. So, thank you all of you, take care, bye bye, see you in my next second part video. Thank you, bye bye.